Good morning. Today I'm going to look at a couple of cases, important recent cases in the New South Wales Court of Appeal, which discuss something that's always at the back of people's minds, I guess, when doing any legal work, and that is the extent to which advocates' immunity extends to work which is being done either actually at trial or more usually these days in preparation for trial. And remember, of course, although the name is advocates' immunity, it actually extends to a whole lot of work done by solicitors as well in terms of getting a matter up to speed and ready for trial. What are the cases? Well, one involves a firm I know very well, Jackson Lalic, Jackson Lalic, Lalic lawyers, and Attwells, Attwells, 2014 NSWCA 335. And the other one is also New South Wales Court of Appeal, Young and Hones, Hones, 2014 NSWCA 337. So judgments given on the 1st of October, both looking at the question of whether advocates' immunity extends to work being done by solicitors and barristers in the preparation and carrying out of a trial. Jackson Lalic, the complaint was that a settlement had been entered which in effect made the defendants liable for far more than they might otherwise have been liable for if the matter had actually gone to trial. And how that occurred is not really explained, but settlement was entered, and question then of whether or not there was some liability for entering a settlement which, in a sense, incurred a far greater potential liability. And when we look at this area, of course, we're looking back to the main High Court case, which is Daughter, Askaree and Victoria Legal Aid, 2005 HCA 12, and it's also at 223 Commonwealth Law Reports at page 1, which we'll now just call Daughter, D'(ORTA). And when looking at advocates' immunity, the High Court in that case and subsequent cases has stressed the need for finality in litigation. That seems to be the key point. You've got to have an end to litigation, and if there's a potential for relitigating in the sense of complaining about something that's happened at trial or integrally bound up with the trial, then you're going to relitigate. And it's clear, as Chief Justice Bathurst points out at paragraph 25 in Jackson Lalic, that the advocate's immunity can also extend to a negligent omission, and the key point is to determine precisely what the scope of the retainer or remedy was. You've got to identify the breach basically and see what's happened. So, did that particular case, Jackson Lalic, did it fall within the scope of the advocate's immunity? And that's discussed in detail, paragraphs 33 and following. And there has been a suggestion from time to time that failing to advise against possible actions against third parties might fall outside the scope of the immunity, failure to advise on commencing proceedings in a particular jurisdiction, and possibly negligent compromise of appeals which lead to the loss of benefits obtained in first instance. All of those might, in fact, be outside the scope of the immunity. But at paragraph 36, quoting Daughter and the plurality at 86, the High Court there and Chief Justice Bathurst here tells us that there's no need to depart from the test for advocate's immunity described in Gianarelli and Wraith, which is the older case, of course, reconfirmed in Daughter. Gianarelli and Wraith, 1988, High Court of Australia 52, 165 CLR 543 at 560, where the test was described as one which extends to work done in court or work done out of court which leads to a decision affecting the conduct of the case in court. And in that earlier case, Daughter, the High Court did not consider there was any difference in stating the latter part of the test as work intimately connected with the work in court. So, if you've got a close degree of connection between what's done and what actually happens in court, if it's intimately connected, or if it's closely connected or leads to a decision affecting the court decision, then that will be protected by the immunity. Well, of course, if you apply that test here, pretty clear that Jackson Lalic is going to be within the scope of the immunity, and so the Chief Justice concludes. Paragraph 37, he says, in the present case, in my opinion, the work fell within the categories of work done out of court affecting the conduct of the case in court. The alleged breach occurred in advising on settlement of the guarantee during the luncheon adjournment on the first day of the hearing, and more importantly on the evening of that day. And the advice led to the case being settled. Put another way, it was intimately connected with the conduct of the guarantee proceedings. Paragraphs 37 and 38. Secondly, as he points out, that paragraph 41, the current proceedings, that's to say the ones being brought against Jackson Lalic, no doubt protected or defended by the insurers, of course, professional insurers would have been in. The current proceedings do involve a re-agitation of the issues raised in the earlier litigation. It's fundamental to the claim that the judgment entered was wrong and the incorrect result was due to the negligence of the applicant. This necessarily involves consideration of the issues raised in the earlier litigation to determine whether in fact the applicant's advice was negligent. In that sense, it offends against the principle of finality of litigation. And then Chief Justice goes on to distinguish an important case, Donnellan and Watson, Donellan versus Watson, where there were consent orders, and it looks as if in fact the agent was acting outside the scope of his authority in settling. That seems to be a different case. Perhaps that sort of case, along with mistakes as to jurisdiction and the like, might still fall outside the immunity. But it seems that if you've got a fair degree of connection with court, the High Court and Court of Appeal don't like you tampering with it. And that's been confirmed by the decision on the same day I mentioned, Young and Holmes, 2014 NSWCA 337. Once again, a complaint really about the way in which a case had been conducted in terms of getting a suitable settlement or a suitable result in the Land Environment Court, suggestion that there should have been some other sort of relief claimed, etc., etc. And the applicant wasn't happy about it once the matter was settled, and long judgment by Justice Julie Ward, I think, Justice Ward, an appeal from Justice Garling, yes, Justice Ward, and Justice Ward's really, at paragraphs 187 and following, looks at the question of immunity herself, and 188, she says this: the advocate's immunity from suit extends to advice or work done out of court, which leads to a decision affecting the conduct of a case in court. And she cites naturally Gianarelli and Daughter, Donnellan and Keefe and Marks. And she notes in relation to the earlier case that pretrial work might be so intimately connected with the conduct of the cause in court that it can be fairly said to be a preliminary decision affecting the way that cause was to be conducted when it came to a hearing. Alright, so that seems to be the relevant test. And at 189 she points out that in Daughter, the plurality did not see any significant difference between the test as expressed in Gianarelli and the formulation by Chief Justice Gleeson and Keefe and Marks as to work intimately connected with the work in court. And what needs to be emphasised is that it's made by the nature of the complaint made by the disappointed client who is seeking to sue the advocate. And what normally falls within it? Well, something, of course, that's required prior to hearing, prior to the commencement of hearing, but throughout the hearing up to the conclusion of the hearing. And Sir Mary Gleeson says in Keefe and Marks, page 718, interviewing plaintiff and any other potential witnesses, giving advice, making decisions about what witnesses to call and not to call, working up any necessary legal arguments, giving consideration to the adequacy of the pleadings, and if appropriate, causing any necessary steps to be undertaken to have the pleadings amended. So all those matters are protected, and in this particular case that immunity extended to the way in which the case had been pleaded below in terms of a remedy. Alright, so two very interesting cases there, and quite important ones, underlining, I guess, the protection which both barristers and solicitors enjoy. There's a fair degree of agitation and complaint about it, of course, because lawyers are in a privileged position compared with most other professions. You're not protected if you're giving advice on a survey or an accountant's report or the like. But, of course, the problem with court cases is that it's very easy to be the Monday morning halfback, as we say, watch the case and think, oh goodness, I would have done that slightly differently. For the result, hindsight's always 20/20, of course. I would have made a different decision, and if that happens and you've got an aggrieved litigant, then I guess there's infinite scope for re-agitation of events that have already been concluded one way or another. And I guess the old Ciceronian maxim, inter re publicae ut sit finis litium, it's a matter of great state importance that there be an end to litigation, applies in this particular context. Not sure what will happen. In certain other jurisdictions, its protection's been watered down. present High Court seems pretty firm in favour of it, although there was some dissents in Daughter, and it'll be a question over time as to whether it's gradually impaired or not. But have a look at those two cases, Jackson Lalic and Holmes' case, both important decisions, reconfirming the present position and I guess providing comfort for the coal watchers of the night if you think you might have made a slight snafu in terms of running a case or the like. And it seems to extend pretty much into all necessary and integral parts of either preparing the case or indeed settling the case outside court.